Okay, so hi everyone. Welcome to the lecture. This is week 3 for criminal law, and as I said in the intro video, today we're talking about constitutional protections, due process, equal protections, the Constitution, and the rights within. So we're just gonna, really get right into it right away. And so, typically speaking, there are two types of constitutional protections for the defendant, and that's the constitutionality of a statute and procedural justice. Now, if you've taken other criminal justice courses, you'll already be familiar with the concept of procedural justice, but we'll still go over it here. So, very specifically, why we're talking about the constitutional protections for defendants is partly because they are the ones that have the most to lose in a criminal case. So, completely speaking, it's not saying that there aren't constitutional protections for the prosecution, because there are. But our focus, at least in this class and in this lecture right now, we're really focusing on how the court system and how it operates in regards to defendants, people who are being charged or accused of having committed a crime, and what that looks like, what kind of things are there to make sure that they can still be treated fairly in the system. So that's why typically there are two types of constitutional protections, and we're going to talk about each one of them. So the first one is the constitutionality of a statute. So, brief reminder, a statute is any written law that has typically been passed through Congress or some kind of legislative branch. So, the idea here is that we're looking at the constitutionality of a written law. So, we're really seeing whether a written law has an issue with the Constitution. And so, obviously, it's why today we're going to be talking about Constitution and the rights that citizens have within the Constitution, because if a law is seen to be going against the Constitution, it becomes unconstitutional. Pretty straightforward and pretty obvious answer there. What's important is that this is an issue that consistently happens, and why we have to have these conversations is the reality that laws are made all the time, and if we didn't have this idea that we could hold it in balance, well, then people could make laws basically about anything. And yes, ignoring a couple current examples going on in our country right now that seem to be going against this idea, which is a whole complicated matter, the general idea is that if a law is going against a constitutional right, it cannot be officially enacted. It means you cannot charge someone for it. You cannot proceed with that particular call. So that's what we're talking about here. So when we talk about the constitutionality of a statute, there's two different ways to look at it. There's something that's unconstitutional on its face, and when something's unconstitutional as applied. And this should be pretty straightforward, and it's why I, have very simple terminology written here. Unconstitutional on its face is, we're looking at it, the law is invalid in any circumstance. And the reason for this is because the actual wording is unconstitutional. So we're looking at anything where it says you lose this right. It would be invalid because it goes against the actual constitutional rights. Unconstitutional as applied is where a statute or a law is invalid in certain circumstances. And how we understand that is the enforcement of the law is unconstitutional. So this would be if there is a law that particularly addresses an illegal action that is illegal for everyone, but it seems to only be enforced with one particular group of people or one person when others are not, that could be unconstitutional as applied, where the rules for applying it are not being properly followed. So, while there are two different ways to view whether a law is constitutional or not, the reality is that if a defendant chooses to argue and debate the constitutionality of a statute, it doesn't have to be one or the other. It can be both. The law itself can be unconstitutional in its actual wording, and it can be unconstitutional in the way it's enforced. It can be only one of them, but it can be both. And that's kind of an important notion to keep in mind, especially as we start talking about more laws and talk about specific laws. Especially when we start talking about rights, this is going to become clearer on what we mean when the wording can be, or the way it's enforced, or it can be both. So the other way that the constitutional protection for a defendant is in the procedural rights, the procedural justice of the system. And so the most obvious and clear example that we understand as procedural justice is the idea of having a trial by jury. We understand that here in this country, during a criminal case, it is your right as an American citizen to have a trial by a jury of your peers. You can waive that right, but you have the right to have a trial by jury. Obviously, this is not the only thing that's procedural justice. Procedural justice really is just the rules that are set out to make sure that everyone has as fair and equal of an opportunity as possible in the system. And so the other thing to note about this is not just in the court system, like not just during a trial. This is including, but not limited to, during the arrest, during interrogation, during searches, during filing of charges, during the trial, and during appeals. The idea here is that procedural justice plays out throughout the system. The moment it starts to the moment you're out of it, there are procedural rights in place that protect you, whether you're found guilty or not. There are processes in place to protect you. Within the trial part itself, usually the defense can make a motion to dismiss charges, suppress evidence, or even declare a mistrial, which are all three very specific type of motions that are part of the procedural justice protection of a defendant. Obviously, dismissing the charges is exactly what it sounds like, saying that these charges are not accurate, are not valid, and should not be applied to an individual. Suppressing evidence also makes a lot of logical sense and is straightforward, which means, suppressing evidence, not allowing evidence to be used, and then declaring a mistrial, essentially saying that part of the procedure of the trial is inaccurate, unfair, and is against the concept of justice, and therefore cannot be valid to be used to determine guilt. So, our whole big takeaway from these two general constitutional protections is that the protection can be related to how the system operates, but it can also be a little more, and I hate to say devious, but devious, because constitutionality of a statute is a devious thing. Procedural justice is just to make sure that everything is fair, but talking about whether or not a law is fair or being unjustly applied to people, that's a whole nother mess. But it is something worth talking about. And that's why these are the two general ways, two general types of constitutional protections that we see applied to a defendant in trial, in court. So, when we talk about constitutional rights, there's a couple things that we need to talk about. And unfortunately, I know this is definitely going to sound controversial, and I want to emphasize not that I agree or disagree with this, but it's important to note that constitutional rights may be guaranteed of all citizens of the United States, but there are also rules to be followed. There are understandings that sometimes when you violate the rules of order that you lose out on certain rights, and that's we're going to get into that in a little bit. But what's important is to know that we actually do have a system in place to review constitutional rights, to make sure that they are valid, that they are happening, that when we try to introduce new ones, that they make sense logically and accurately and work. So we do have standards of review in regards to constitutional rights. And so, very basically, at the highest level possible, the typical goal is to balance. And what I mean is that when we discuss constitutional rights, when we're looking at whether this is something that can be considered, yes, a constitutional right or not a violation of a constitutional right, we're looking at the balance between the government's interest and an individual's interest. The more clear way of explaining that is the right to regulate conduct and activity and the freedom to be yourself. At the end of the day, things that we pretty much understand well as citizens of the United States, and we're going to talk about the First Amendment, the freedom of speech, in a little bit, but the idea here is the freedom of speech. Well, what does that actually mean? What is the balance between the government's interest and the individual's interest? Well, the freedom to be yourself has to do with your ability to say and speak freely. In a lot of countries, if you speak out against the government or people in power, you can get jailed or killed. In this country, traditionally speaking, you have that right to speak ill of the government and not get arrested in the middle of the night and hauled off somewhere. Do we know that it does occasionally happen here? Yes. But the idea is that in general, you have that freedom. And of course, like I said, the right of the government's interest, their right to regulate conduct and activity. It's why we have conversations where not all speech is protected because, well, you need to be able to regulate how conduct is enacted, what's appropriate behavior, what's inappropriate behavior, things like that. Is a riot a protected form of speech and expression? No, we are going to talk about that in a little bit. But the right to riot is not constitutionally protected. The freedom to be yourself is one thing, but rioting involves violence and damage and things like that, and that's goes against the concept of civil society. So, of course, regulate conduct and activity is going to supersede the right to be a violent protester. So that's why I said there are rules for it, and it's important to understand that this balance is what we're trying to find. We're trying to find that nice middle point. So when we do review whether a constitutional right is being protected and is a part of a right or is not, we have to have some kind of testing method. And so we do have a rational basis test, which we'll talk about here in a second, but we also do strict scrutiny. And so for the fundamental constitutional protections, things like freedom of speech, freedom of religion, right to bear arms, the free from cruel and unusual punishment, due process, right to privacy, things like this, these are considered fundamental constitutional protections. These are the core tenets of what it means to be an American citizen. And so most violations that happen are considered invalid, meaning that they don't have grounds to say, well, it wasn't actually wrong. We were in the right to violate their amendment, their constitutional rights. No, most violations are considered invalid immediately. And that's if they are somehow upheld, any restrictions must be done in the least restrictive way possible. So, for example, freedom of speech. It is your right to say things negative of the government in this country. If somehow the speech that you were giving about how terrible our government was led to a small group of individuals, like 40 people, to violently attack a group of people simply because of what you said, well, they would argue that you don't have that right. But because you're allowed to speak negatively, any punishment must be done in the least restrictive way possible. So it might be something like, well, you're free to say that, but you can't say that on a private website or on a public website, or rather. Something like you can't say it on Facebook, but you can say it on your personal blog. That kind of idea. You can restrict them, but if they are a fundamental constitutional protection, it has to be the least invasive as possible. That's strict scrutiny. The rational basis test is used for non-fundamental protections. These are a lot of the other things. And so what this rational basis test looks at really is it rationally related to a legitimate government interest? Notice it's got a lower requirement to meet, and that's why it really is whatever action that's being taken, is it something that has a legitimate impact to the government, that the government would have a serious interest in? If it is, then yeah, they can kind of come in and say, yeah, this isn't protected. So the overall basic fundamentals of this, what I'm trying to hopefully put forward to you, is that there are limits to what the legislative branch can and can't do. There are limits. You can't just arrest someone because they said something hurtful. There has to be more to it. And so when we talk about limits, if you've taken Intro to Criminal Justice, especially if you've taken it with me, a couple of these might look familiar to you, and we are going to talk about each one of them separately and a little more in depth. But some common limits that we need to talk about are bill of attainder, ex post facto, void for vagueness, and overbreadth. But we do need to talk about, in this conversation, we need to talk about the due process clause as well as the equal protection clause. So when we get to those, you'll understand why they're different, but they're still part of this limits conversation. So let's just start with the first one, the bill of attainder. And the concept of a bill of attainder is that you punish a defendant without giving them a trial. So if a statute that targets an individual or group for some type of government sanction, the idea here is that if somebody commits a crime, if they had a bill of attainder, their concept would be, oh, well, we already know they did it, so let's just put them in jail for an extended period of time to deal with their crime without ever having any kind of trial, without having any kind of official procedure, just immediately putting them away. Clearly, this violates the right to a fair and speedy trial. This is violating the right of due process. This is literally a big problem. So, a limit is that you cannot obtain a bill of attainder. Historically speaking, this has been a problem in the past, where individuals could arrest someone for committing a crime and not have a judge or anyone sign off on it, just lock them up indefinitely. As we talk about rights, that clearly goes against that idea. So this is why this is a limit, to make sure that this does not happen. The other one that should be familiar to those who have taken intro before would be ex post facto. If you remember, it was one of those weird Latin ones, which means after the fact. And this literally is punishing someone retroactively or after the fact. So this typically looks like one of these three options, where we punish a behavior before the law officially goes in effect. We increase a punishment for offenses after the crime occurred, or we increase the possibility of conviction after a crime occurred. It's not to say that somebody breaks the law and we make it illegal so that we can prosecute people for that. That's not the same thing. It's deciding we're going to change the way the law works so that we can make sure we can catch more people who are maybe accidentally breaking the law, but we're not going to let them know we changed the law. That's really what ex post facto is looking at. It's looking at ways to punish people without it officially being illegal, if that makes any sense. And that's why we focus on punishing behavior before the law goes into effect. And the other big one is increasing punishment for offenses after the crime occurred. So let's say, very generic example, if we said that the charge for having 10 grams of marijuana was 2 years in prison. Pretty light sentence. It's pretty harsh for the punishment or for the crime, but it's a light sentence overall. And somebody comes in and decides, you know what, 2 years really isn't enough. We should put the minimum at 10 years. If they did that, they could not change the minimum sentence for the individual already arrested. They can't say, well, the law changed to be 10 years. You have to now serve another 8 years on the 2 that we promised. That's not how that works. There is a process to make sure that doesn't happen. That would be part of this ex post facto. You're trying to get more punishment for an offense. Now, if a change would benefit a defendant, it is not considered an ex post facto issue. So, same example, now we're switching the years. If a harsh law goes in place that says if you are caught with 10 grams of marijuana, you get 10 years minimum in prison. 1 year for each gram. And you're in your 3rd year of your sentence, and someone else comes in and changes the law and goes, you know what? That's ridiculous. Let's lower it down to 2 years. Technically speaking, because it's making it less serious and less impactful, the individual could make an appeal to get out early because the law changed. So it would benefit them, but it can't make it harsher for them. And I want to mention this concept, the ex post facto rules and everything, this only applies to criminal law. There are ex post facto rules in civil law, but they're very different. And because our focus in this class is criminal law, these are the ones that we're focused on and talking about. So just a brief thing. In civil, raising fees or taxes after making a payment in civil is not considered an ex post facto issue. So they can do that. But in criminal charges, they cannot do that. Okay. So let's talk about due process right now. Because definitely thinking about Bill of Attainder and thinking about ex post facto, due process comes in. And so our due process clause, we get a little bit from our Fifth Amendment, which roughly states, no person shall be deprived of life, liberty, or property without due process of the law. And so what this means, and I'm not kidding, what I mean is that if the government is going to intervene and take someone's life, liberty, or property, their freedom, their physical life, or something they own, that has to be followed with actual process, making sure that it's not just someone makes a claim and, oh, you lose everything, because that's not due process. Due process is making sure that there are rules that are followed to make sure that everyone is treated fairly. So, there are 2 types of due process, and this is where I say we don't really get into this in Intro to Criminal Justice. This is where we start talking deeper. So there's substantive and procedural. And substantive due process really protects individuals from an unreasonable loss of substantive rights, like speaking freely and the right to privacy. So when we talk about these, we're talking about, again, those serious types of behaviors that people have, your inalienable rights. Whereas procedural due process, really, its design is to protect individuals from being criminally punished without notice and an opportunity to be heard. In other words, the chance to, go to court, speak your piece, present evidence, present defense says that I didn't do it. Substantive due process is focused on things that keep your rights in place. Procedural due process is to make sure that the system works in your, not necessarily in your favor, but to be fair for you. And so one thing that I do want to talk about briefly that's not written here, but I want to just say a little bit. When we talk about life, liberty, and property, there are criminal charges that are doing this very specific life, liberty, and property piece. So obviously, life, the punishment that's connected to life most appropriately is capital punishment, or the death penalty as most people understand it and know it. Liberty, where freedom has to do with incarceration, being locked up. And property, which the term is forfeiture. And forfeiture is a punishment of criminal activity where you can give up either property that was obtained via ill-gained finances and goods and things like that, or it can be as a punishment to repay a debt to society. So there are punishments that are connected to each one of these, and that's why we have to have this understanding that the government can't just take it away from you. There has to be a legitimate reason, and there has to be not only legitimate reason, but protections to make sure the government can't make it up. So, void for vagueness. This is the third component that I know at least I talk about in Intro to Criminal Justice. So if you've taken my Intro to Criminal Justice, they should be familiar to you. The Bill of Attainder, ex post facto, and void for vagueness. If not, well, you're hearing them now from me. So void for vagueness, under due process, void for vagueness challenges the exact wording of a statute. Let me say that again, because this is something that people sometimes get confused on. With the idea of due process and the due process clause, void for vagueness is a challenge to the exact wording of a statute. And typically, the reason for this is it can be void for vagueness if words that are used in that law or that statute are indefinite or ambiguous. What we mean is that there's too much discretion when reading a law. A direct quote to understand void for vagueness is that men of common intelligence must guess at its meaning. If you have to guess at what a law means, it's void for vagueness. It's too vague. This is where I say, if you've taken English Comp 1, we talk about arguments of facts and arguments of definition. This is why those things are important. Because if your words are ambiguous, if they are hard to understand and decipher, that leads to problems. You want to make sure that what you say is exactly what you say and how you mean it. Especially if you're going into law. What you say matters. So void for vagueness is an important piece to make sure that if somehow a law was awkwardly worded, like you must, I can't even think of a good example. You must be a righteous person. Righteous is a weird term. It doesn't have a direct one-to-one meaning, and so therefore it's vague, and that's a problem. All right, let's talk about overbreadth. And this is one that we've not talked about in previous classes, at least I haven't, so this one typically is new to most students. And so overbreadth means to be overly broad. And so a statute is overbroad if it criminalizes both constitutionally protected and unprotected content or conduct. Essentially, it criminalizes too much. This is the opposite of void for vagueness. Being void for vagueness means it's not really clear. You have to understand. There's too much nuance to it. Overbreadth literally means that you are overreaching. You're trying to criminalize way too many things, and really it needs to be focused. And we've actually seen this happen a couple times in more modern times, where a new law is being put forward, and the argument is there's too much going on in it. It needs to be focused on just the issue at hand. So this is what we're talking about when we say overbreadth. We're talking very wide speaking ideas. Things that lose its power because it's too spread out. So that brings us to the Equal Protection Clause. And that comes from the 14th Amendment mainly. And specifically, the phrasing that I want to talk about is, nor shall any state deny to any person within its jurisdiction the equal protections of the law. And I do want to emphasize something very specific on that. Nor shall any state deny to any person within its jurisdiction the equal protections of the law. Please notice any person. It does not specify citizen. This is an important aspect of equal protection that has been contended currently in this current administration, and it's kind of difficult to talk about. Technically speaking, if you are on American soil, you have equal protection. Because the law, the 14th Amendment says that if you are within the jurisdiction of a state or the United States itself, you have equal protections of the law. You get to have all the benefits and negative associated components of the legal system. That's an important piece, because what this is trying to do is prevent the state government from enacting criminal laws that discriminate in an unreasonable and unjustified manner. Yes. Prevent state government or federal government from enacting criminal laws that discriminate in an unreasonable and unjustified manner. And that requires me to put this reasonable and just discrimination, ? So, I really struggle to talk about this because it's hard to think that any discrimination could be reasonable and just, because that becomes a slippery slope. And you're right. So, I would like to address this legally, not as a teacher, not as a human being, not as a citizen of the United States, but as a teacher from the legal standpoint, what our law states and how things are viewed. If the discrimination of a law is arbitrary, strict scrutiny is used in determining justness and reasonableness. When we say arbitrary, we're talking things like race, religion, sexuality, ethnicity, those types of things. Those are arbitrary decisions Then if they're going to determine if it is something that violates equal protection, they're going to use strict scrutiny to see, is this just? Is this reasonable? If the discrimination is not arbitrary, the rational basis is all that's needed to support that decision. When I say not arbitrary, the one that we most associate with and discuss with this is previous offenders. Somebody who has a history of criminal behavior and being sentenced. That they tend to consider a reasonable and just discrimination is things that have to do with former felons or repeat offenders. This is why I say, I'm not saying it as a teacher, as a person. I'm not saying that a repeat offender is allowed to be justifiably discriminated against. But in the way that our system works and is operated, it kind of does, and that is complicated. That is a mess that I really don't want to talk about, but it's important to understand. So equal protection is trying to prevent the government from creating any kind of laws and enforcing them that discriminate against any individual in an unreasonable or unjustified manner. That's what we're talking about here. Okay? So, let's talk about some of our constitutional rights, because that's, I think, pretty much the rest of the lectures, talking about those rights and a couple things here and there. So the freedom of speech. So judicial opinion, aka judges talking about these things and have put forward as their law what they agree on. Judicial opinion has come to categorize speech, and this is why I'm saying this, as virtually any form of expression. If we took freedom of speech to be just what people say, it misses a lot of ways that people express themselves. And so, judges have agreed over the years that freedom of speech doesn't just include what you say, but it's also what you do. So it is verbal and written words, but it can also be things like pictures and photographs and even videos. Would you be fair to argue that a picture of something could be someone's speech? They could be trying to say a message with only images? Yeah. So this is why we've had a different conversation about what speech is. Because we understand the power of songwriting and lyrics and things like that, songs are a type of speech. Now, expressive conduct is counted as speech. And I want to point out, dressing is part of speech. This can mean cross-dressing, drag. This can be wearing particular types of clothing, identifying, I support cowboy, so I'm wearing cowboy outfit. Like, dressing is a form of expression. Flag burning is a form of expression, and I want to emphasize, it is not technically illegal to burn a flag, even the American flag. It is an object to a lot of Americans that holds great sanctity and seriousness, and so people are offended by a flag burning, but it is technically a form of speech, and that is protected. And that's why there's another one, and it's the one I have an asterisk next to, and that's cross burning. So, technically speaking, the freedom of religion is part of this First Amendment. So, your freedom of speech, you have the right to burn a cross. However, there is a very big but on that. And that's why it has that asterisk. While flag burning is a protected expression, cross burning has a long and deep history of being a clear marker from the Ku Klux Klan about black community members and telling them to essentially leave or they will be attacked. So, because of its racist connections, cross burning tends to not be looked as fondly upon as the rest of the free speech things. So while it is a technical form of free speech, its context can be viewed as hate speech, which is not protected. So it gets a little weird. That's why I put that one with an asterisk, because it's difficult to talk about, but it's important to understand that when we say speech, we mean a lot of things, especially a lot of things that people are uncomfortable with, because unfortunately that's someone's right, is to speak and express their thoughts and their feelings. So when we are concerned with the freedom of speech, strict scrutiny is used here. Remember, I said all of those immutable things that we all have, these are the things that are looked at with strict scrutiny when we're trying to enforce it or make rules or punish someone. So it's used here for freedom of speech violations. And we use it especially to look for exceptions to free speech coverage. And that's where we get to talk about this. The exceptions to free speech. So, completely serious. Just because you have the freedom to say things does not mean that you are free from punishment. The First Amendment protects you from the government punishing you for your speech. It does not protect you from saying hateful things and a private citizen to be upset and retaliate against you. Does it protect you necessarily from getting beaten up for something you said? Maybe. And that's where these exceptions to free speech come in. The four primary exceptions to the freedom of speech are fighting words, incitement to riot, hate crimes, and obscenity. So, fighting words are very straightforward. They are when there's presenting clear and present imminent danger. It's not just, hey, you want to fight? That's not fighting words. Fighting words are as language that's used that's essentially threatening someone. That's fighting words. Presenting clear and present danger that's imminent, that's going to happen soon. That's what we're talking about with fighting terms, or fighting words. I will say that statutes limiting the freedom of speech, specifically using fighting words, is rarer nowadays. But we do still see these come up in other ways, and that's why I emphasize fighting words is not as commonly addressed anymore, but the other ones, yes. So the incitement to riot is where there's an imminent lawless action to occur. I try not to get political. I try to keep apolitical as possible, but it is important to note, legally speaking, based wholly on things that occurred, the January 6th riot and the speech that President Donald Trump gave on that day, the reason that there was an investigation into it was because the wording he used was enough to incite lawless action. How culpable he is was something that the case was trying to figure out, but this is what they addressed, is that his First Amendment right was actually not there because his words were what led to a lawless attack on the Capitol. So this is what incitement to riot is, and it's why it's important to note that this is the issue that initially was brought up, and why they had to do an investigation and court case into this was how culpable is the president's words in the resulting actions. And so this is where that incitement to riot comes in, why I said we still see these things come up. Hate speech and hate crimes, on the other hand, is complicated. And I know that seems weird to say, but it is complicated. In regards to hate crime, speech or content that is being addressed as hate crimes, if there is clear and imminent danger present, or with the intent to intimidate or harm a group of people because of who they are, that's hate crimes, and hate speech in particular. Remember when I said the burning of a cross? Burning a cross isn't inherently wrong, but if the intent is intimidate and say, if you don't leave, you'll be next, then yes, that's a hate crime. This is why I said this one's a little bit weirder. Essentially, break it down to, if the content or opinion or speech or whatever it is targeting a particular group, and it's very clear that there is some kind of either danger going to happen or will happen soon, and the goal is to intimidate or harm someone, then it's considered hate speech. It's a hate crime. Obscenity is inappropriate. Full stop. That's what obscenity is. It's a terrible definition, but the concept of obscenity is it's obscene to be obscene, aka it's raunchy and crude just for that purpose. And that actually has its own separate thing that we need to talk about. And so this is a criminal law class. We talk about a lot of different laws. And we're going to talk about two today. One a little bit more in depth, and the other, this is the one in depth, and that's Miller versus California, 1973. If you took my first 8-week intro to criminal justice, we actually talked about this a little bit in class, just simply as a special topics piece, but it's relevant specifically here when we talk about the First Amendment, because in Miller versus California, California was charging Mr. Miller, who owned a pornographic bookstore, a pornographic store, in the 1970s, and it had been running for a while. And some local watchdog group was really upset that he had pornography, and they were like, "Hey, this is obscene language. This is obscene material, and nobody should be seeing this. No kids. No, it's wrong. We need to shut it down." And so the local jurisdiction that he was in tried to shut down his store. And he said, "You can't do that." And so he fought the case, and he took it to the Supreme Court. And the Supreme Court actually went, "You know what? You're right. It's not fair what is happening." And so as a result of the Miller versus California case, there was now established a 3-part test to determine whether or not speech was seen as obscene. Because if we're going to have an exception to your freedom of speech, we need to understand what really is obscene. And so the 3 parts are, number 1, the average person applying contemporary community standards would find the work as a whole appeals to the prurient interest in sex. And prurient means the excessive interest in sexual matters. So really, the first part of the test is that an average person, just random person, understanding the current community standards from the area they're living in, would find whatever the thing is as a whole, not just a part of it, appeals to that carnal, excessive sexual desire. This is actually one of the things that has prevented some places from considering and banning certain books. Is because even applying community standards, if a book has a single sex scene in it and it's not even that graphic, is the work as a whole appealing to the base carnal instinct desire for sex, or is the rest of the work something else and there just happens to be sex in it? If it's the second one, guess what? It's not passing the obscene speech test, so it's going to be allowed. You can't deny it. So, the second part of this is that the depiction of sexual content in the material and the speech, specifically defined by applicable state laws in a patently offensive way. In other words, is it going against the general sensibilities of what the law means, what is and is not allowed? For very basic things, can you have sex with an animal? In most states, it's a no. So if the content that's being addressed has to do with a human and an animal, it is likely to be not okay. It is offensive, and so it would now not pass the obscene speech test. So it is obscene. I think I confused my first part when I said it didn't pass. It passes the obscene test. My first example, not the animal one. So the third part of this test, and this is the one that gets fuzzy and interesting, is that the work itself lacks serious literary, artistic, political, or scientific value. And so this is important to note. An example that I like to talk about occasionally is things like NWA's Fuck the Police. That's a song. It is a bit of a protest song in early rap hip-hop culture. But the idea is, is it just obscene to say fuck the police? Yes, it is obscene. However, has nothing to do with sex, so the first two parts don't apply. But that last part, does it have serious literary, artistic, political, or scientific value? Yes. It has artistic value and it has political value because it was a political statement talking about police brutality. So, yeah, it passes the obscenity test because, hey, it does actually have artistic and political value. So this is why I say this is a slippery slope. So I am not telling you to do this yourself, but what gets a little bit gray area here is when we talk about performance art. So performance art and performance artists tend to do extreme works that tend to push the limits of what is and is not free speech. A good example of somebody who did this was Gigi Allen. He did that stuff in the 90s and I believe the late 80s. If you are absolutely interested in it, you can look up his story. I do not recommend it. It's very inappropriate and gross, but there were debates about whether or not the things he was doing would pass the Miller test for free speech, and they technically do because they have artistic value, and it's weird, like I said, but it's worth noting that this is why it gets a little bit uncomfortable when we consider obscenity as a component. Is stripping a protected form of expression and speech? Maybe. That was a big hint, by the way, for anyone that's interested. Hint, hint, nudge, nudge. Okay. So, the next thing that we're going to talk about next, constitutional protection, is the right to privacy. And I actually really like pointing this out because usually I like to ask students, what amendment is the right to privacy? And usually I get the blank stares of, I actually don't know. I just know it's a right. And you are right. It's a right that's guaranteed, but it's not explicitly stated in any one place in the Constitution. The right to privacy is not anywhere like this is the right to privacy. It's more of a general understanding based on other rights that eventually led to passing of laws and other things that put forward this as a technical constitutional right. So it does come from the 1st, 3rd, 4th, 5th, 9th, and 14th Amendment. This is very broad overview. Things like the right to speak, assemble, and worship freely has to do with your privacy, what you do in the privacy of, your own life. That the government can't force individuals to quarter, house, or feed soldiers. You can't force a private citizen to open up their house and house and feed 10 soldiers. You just can't do that. The government can't unreasonably search or seize an individual or their property. You have the right to due process of the law, and that things that aren't explicitly covered in the Constitution may still exist and be legitimate issues that need to be covered. That's the big part of that 14th, is that there are things that we haven't thought of because we're not experts. We want to make sure that other things in the future can happen. So, really, the whole point behind the right to privacy was to put in place a barrier between individuals and government regulation. And this isn't the only case. This is just one of the big cases in regards to privacy. And that's Griswold versus Connecticut, 1965. I talk about it in Intro to Criminal Justice. It's an important right. Anyone who has a general history, knowledge, or interest, and knows anything about gay rights and civil rights and even Roe v. Wade, and then Dobbs versus what was it, Jackson Women's Health Organization or whatever it is. Like, if you are interested in that kind of stuff and you've not heard of Griswold versus Connecticut, it's a big case. It's kind of influential in this because Griswold versus Connecticut was all about a couple's right to privacy and to determine whether or not to use birth control in their own home. And so why I say this, and like I said, we're not going super deep into it, but Connecticut at the time had really strict rules on birth control, and pretty much regulating and making it something that you didn't have public access to. And a married couple were having a conversation about going on contraceptives so that they didn't have another child. And a neighbor overheard and called the police and said they're doing this stuff and it's against the rules because they're one of those people that believe that everyone should populate the earth and have lots of babies. And so they got in trouble. And they got charged and they fought it. And they said, you can't charge us for something that we had a discussion in the privacy of our own home. And eventually it came forward that, yeah, you're right. The government can't punish you for something you are doing in the privacy of your own home as long as it's not outwardly evil or wrong and illegal, like, making meth, killing people, things like that. So Griswold versus Connecticut laid the groundwork for the government can't overstep and control every part of your life. So it's an important aspect of the right to privacy, and it's why we talk about it here. All right. The right to bear arms, the Second Amendment. This is honestly a moderately recent debate. I think just about anyone can understand that. The Second Amendment rights really only began in the 1900s. This is not something that's been, debated since the founding of our country. It is a modern issue. And so we'll address this as quickly as possible. The actual statement of the right to bear arms is that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So, we have since had many discussions on this. I think it's Heller versus DC. But a long story short, in the modern era, in the 2000s, an individual had an issue with DC rules that said that they couldn't own a handgun, and so they fought about it, and it had a legitimate overreach by not overreach, but have a statement by Supreme Court, because they went, yeah, the phrasing of it is outdated. The reality is we understand that a well-regulated militia is not necessarily a requirement for a country that has a fairly well-prepared military. But the right to own a weapon is still something that should be allowed specifically for self-defense purposes. So we basically agreed that ownership for self-defense purposes is allowed. It does get a little fuzzy when we talk about if it's home protection, school protection, public protection. Like, it gets a little weird and funky, and why we consistently have debates and discussions about what kind of rules in place should happen and things like that. And I want to mention, I am not saying we should take away guns. I'm not saying that we shouldn't touch guns at all. That's not what we're talking about. What we're talking about is that a constitutional right like this has clearly adapted and changed over time, and it still continues to change. And that's important, because all the stuff we're talking about, all this, discussion of laws and how they change, and it's important to note that even the oldest things can still change. So currently, in our system, there are restrictions on owning a weapon, or a firearm in particular, related to someone with a felony, people with mental illness. I do know specifically, I don't have it written here, but they did recently try pushing, and I believe it passed, that if you have a history of domestic abuse or domestic violence, that you are not allowed to own a firearm either, which is part of that piece of, changing what restrictions are available. For the most part, I do say most schools, and I believe all government buildings, you are not allowed to carry a firearm with you unless you are an armed officer and you have permission to be there. But as a private citizen, you are not allowed to have them. As well as general restrictions on the commercial sale of firearms, like what can and can't be sold, accessories, whatnot, things like that. So, obviously, there's more discussions that need to be had about this, and there is plenty to talk about, but really, I'm trying to focus on, these are things that change with time. So, we get to talk about excessive punishment, and that's connected to the Eighth Amendment. The Eighth Amendment's thing is talking about you're free from cruel and unusual punishment. And so, cruel punishment is usually just associated with the term inhumane. Inhumane punishment, aka things that belittle or diminish the human aspect of the individual. Those are not okay. Oftentimes, cruel punishment and inhumane treatment is connected to the death penalty. I'm not saying the death penalty is wrong. I'm not saying it's right. But it's important to note that a lot of arguments about cruel punishment stem from conversations about the death penalty. In 2024, 27 states have the death penalty. I believe that's still accurate today. Pennsylvania does have the death penalty, however, we have not executed someone in quite a long time. What is important is that inhumane capital punishment looks at execution methods. It is generally accepted that lethal injection is the least inhumane method. It is the most humane way of killing a person. The reason I say this is there often comes a debate with students about what do you mean inhumane capital punishment? What do you mean an inhumane death? So, death by hanging has been outlawed in all 50 states. Death by firing squad was outlawed in all 50 states until Texas brought it back. And I believe a couple others are considering bringing back death by firing squad. And death by electrocution was seen as fairly inhumane by a lot of places, and so they outlawed it and went to lethal injection. And because the lethal injection, when done correctly and properly, is the least impactful harm-wise to the individual. Again, I'm not saying it's right or wrong, but it's important to note that this is what we mean when we say inhumane. This is how we allow execution to be a punishment that's not considered excessive, is because that humane concept, that it's not cruel. All right. As far as a slightly different part of excessive punishment, the one that's not connected to the death penalty, is disproportionate punishment. And that really is just that the punishment is too harsh for the crime. Going back to my earlier example of you have 10 grams of marijuana and you get charged with 10 years, that's excessive punishment. That's way too harsh for the crime. So, yeah, excessive punishment, the Eighth Amendment really is making sure that you can't just be locked up forever for stealing. You can't be put to death because you ran away from home when you were 17. That's not fair. That's not right. So, in regards to that, we need to talk a little bit about sentencing. And this is the kind of like weird wrap-up thing to kind of bring us back to the larger conversation about our court system. So, with sentencing, it's important to note that, it is the part of the trial where after someone was found guilty, they go through the sentencing process where they find out what is their punishment going to be. So something that's important to note, and I know I'm putting it in sentencing, but it's relevant to this, is that an individual can waive their right to a jury. You can waive your right to have a trial by jury. And if you do so, well, then it's only the judge, and that becomes a kind of mess. Because the jury is part of the sentencing and decision-making in a traditional trial. So if you waive your right to a jury, you kind of give up the right to have a group of people determine your fate. You leave it to one person. So, in particular, for the death penalty, there is always a separate sentence hearing that's separate from the trial. And the whole reason they do this is they want to make sure that pursuing the death penalty is the right option. Because, considering the death penalty, it is the only charge that, if successful, cannot ever be taken back. If you charge someone to life in prison and you find out they were innocent later, you can release them. You cannot bring someone back from the dead. So truly speaking, if the death penalty is going to be the punishment, they hold a separate mini hearing and trial type thing. It's not a trial, but they hold a separate hearing to kind of discuss the nature of the death penalty, what it means, and other options to see, is this the right answer or not. So it's important to note that those decisions aren't made lightly. And then the other thing with sentencing that I want to talk about is that a judge cannot enhance a punishment beyond the statutory maximum based on facts determined by a jury beyond a reasonable doubt. What I mean is that, first off, all statutes, all laws come with minimum and maximum sentencing. There are guidelines to how long a person can be punished for a crime. A judge cannot decide to punish someone beyond the maximum based on facts determined by a jury beyond a reasonable doubt. If a jury found that someone was guilty of something and they give a recommendation of a set years for charge, the judge can't decide, I'm going to go past what the maximum is. I'm going to give him an extra 20 years. You can't do that. There are rules and guidelines in place that are protections. That's part of the cruel and unusual punishment, has to do with sentencing and to make sure that a judge cannot punish you extra hard for your crime. And with that, that brings us to the end. I want to thank everyone for listening, taking the time. I know this one was a little bit longer than normal, just because there was a lot to talk about. But I hope everyone has a wonderful day, and I will see you in the next video.